I'm Alan Tannenbaum. You'll note that our firm name has changed to Hill Tannenbaum. John Lamole, who was a valued partner of the firm, has decided to take his career elsewhere. And we decided to put Cindy Hill's name first to emphasize the fact that our main practice is a general practice, and Cindy has led a general practice in the HOA and condominium field now for 20 years. I've been more on the construction side. So we still have our construction practice, but to emphasize the fact that we are a full range general counsel practice handling all aspects of association general practice. We have renamed ourselves as Hill Tannenbaum. And we're here today with myself and Cindy, Attorney Jim Terps, Attorney Jennifer Hicks, and our new attorney, Tucker Ford, who is a very skilled trial lawyer who has joined our firm to support our construction and litigation practices. So we're welcoming Taylor Ford I said his name wrong. Taylor Ford for his first session with us. So welcome, Taylor.
That's all right, Alan. Pleasure to be here.
Good. Send your questions through chat. We will get as many through them as we can. And at this juncture, I'm going to turn the program over to my partner, Cindy Hill, to take us through the agenda.
Thank you, Alan. Okay, so we are here for running a board meeting for community associations. The requirements, some war stories, and some tips are what we're going to share with you. Really, I can't emphasize enough how important it is to run your board meetings efficiently, to have a well-governed community association, even though we are aware, as we were just discussing, there are some folks that can make that difficult. This is going to work for the majority of your community. When you run board meetings, they're conducted with consistent and legally proper standards and protocols. You're going to present transparent board decisions and information and build community trust. So that's what we're looking to emphasize here today. I'm going to be opening with the general statutory requirements regarding board meetings. Then Jennifer Hicks is going to talk about preparing for board meetings. Jim Terps is then going to talk about the meetings themselves. And in the midst of some of this, and at the end, we are aware the governor recently signed the Bill 913, which is a lot of new laws regarding condominium associations. So we could spend a whole hour on that. We cannot do that, but we are going to touch on some of those new provisions. And we are aware that it did recently pass. And if you're not aware, do be aware of that, because pretty soon on our website, we're going to have some summaries posted up of what that new bill is going to do for condominium associations. And there's some other peripheral bills also that impact management companies, managers, and some other issues that are going to be important to community associations. So watch our website. We're going to have that information up soon. Just as a reminder, our review of the law is statutory on this. We do not know your governing documents. And even if you're our clients and we do know your governing documents, we're not discussing them in a public forum. So we are going over statutes, which can be a little boring, but these statutory requirements are important. That being said, your bylaws might have additional requirements. So make sure that in addition to complying with statutes, you are working with your general counsel and making sure that you're also complying with the particulars of your documents. And before opening, I also want to say we use the term members. There are two different members in your community associations, regardless of whether you're an HOA or a condo. Those two different members are your board members or your board directors, and then your owner members who are not on the board. So be aware that when we use the term members, we might be referring to owner members or we might be referring to board members. We do try to be as clear as we can on that point, but if we do seem to, if any of us throughout the presentation seem to lose you on that point, again, ask a question in the chat. Those of us who are not currently speaking will be monitoring the chat, and we will also try to share some of the questions as we go through and presenting each section at the end. And then at the end, we will, if we have time, do some questions and answers. We are aware that this is a pretty heavy topic. So next slide, please, Michelle. So what is a board meeting? So for a condominium, a meeting of the Board of Administration, and by the way, that's another term that's used. It means Board of Directors, really, but also Board of Administration, means any gathering of the members of the Board of Directors at which a quorum of the members is present for the purpose of conducting association business. So what's a quorum? A quorum is when you have a majority of your board directors. So if you have 5 board directors and 3 of them get together, you have a quorum. So anytime you have board directors that get together and you have enough for a quorum and they're discussing the business of the association, that's a board meeting for condominiums. HOAs, as you can see, have a very similar, a little less wordy, but very similar requirement that a meeting of the board of directors of an association occurs whenever a quorum of the board gathers to conduct association business. So we get a lot of questions along the lines of, can't we have a workshop meeting where we don't notice it to the members, or it's not really a board meeting, we're not going to vote? As you can see, these statutes don't support that position. If you are going to gather again as a quorum, if you again got 5 board directors and 2 of you are getting together, you don't have a quorum. But if you got that 3 or more, you've got a quorum. And if you're gathering for business, it doesn't matter if you're going to vote or not. You're still gathering for business. And that is a board meeting that needs to follow the requirements we're going to discuss as we go forward. Now, that being said, I also occasionally get a client who says, I had somebody at the pool point at me and say, you got together on Saturday with the other board members and had a secret board meeting. And they're like, no, we didn't. We got together on Saturday and we played games and hung out at the pool. If you are getting together socially, you are not having and not discussing association business, even though if there's 3 of you out of the 5, you are not having a board meeting. So to the extent some owners want to be a little overly critical, stand your ground. If you got together as a group and did not discuss association business, but did other things that were almost assuredly going to be more fun, then you did not have a board meeting. Next slide, please, Michelle. Okay, this is another hot button issue, I would say. Board meetings and board decisions made via email. You can share information via email with other board members, but you cannot vote and you cannot conduct business, so to speak, via email. So here are the 2 statutes on point. For condominiums, members of the board administration may use email as a means of communication, but may not cast a vote on an association matter via email. For HOAs, similar. Members of the board of administration may use email as a means of communication, but may not cast a vote on an association matter via email. So email cannot be used to, let's say, avoid what might be perceived the inconvenience of having a board meeting. You're going to have to make your decisions as a board in the open at meetings that are noticed to owners, with a few exceptions I'll get into. Email cannot be used to avoid that obligation. Now, I do get asked, so I'll anticipate that question. What about an emergency, something like a burst pipe or something? We have a burst pipe on the 3rd floor. Do we bring in Fred's Plumbing? Fred being maybe the vendor of choice. Well, of course, you don't need to wait to notice a meeting in the event of a burst pipe. When you have genuine emergencies such as that, and the decision is made to react and do something about that, maybe in an email or maybe even a quick conversation amongst the board that wasn't at a noticed meeting, the solution to that is to ratify that decision at your next open and noticed board meeting to discuss why you made the decision when you did and to affirm that it was a decision that the board approves. So next slide, please, Michelle. So going back to having an open board meeting, what does that mean? An open board meeting is a meeting that any owner in your community can attend. So for condominiums, meeting of the board administration at which a quorum of the members is present are open to all unit owners. I'm going to discuss the exceptions here in a second, but I can't emphasize that enough. Open to all unit owners again. So when you have a meeting of the board where you're doing a workshop or maybe trying to get some business done and you're not noticing it and having the owners attend, that is not in compliance with the statutes. Your meetings have to be open, even if you're not going to vote. That being said, note also they are also only open to unit owners. Your association, whether it's a condominium or a homeowner association, is a private corporation. So the example I give is that some journalist from the Herald Tribune can't just walk into your meetings unless they happen to live there and be a member. You are private corporate meetings, so you do have a right to limit it to owners. But at the same time, don't be closing your meetings to owners unless you are assured you're falling under one of the statutory exceptions. And as you can see here, the statutory exception for condominiums is stated in the Condominium Act. as being meetings between the board or a committee and the association's attorney with respect to proposed or pending litigation if the meeting is held for the purpose of seeking or rendering legal advice. So note that that's for proposed or pending litigation. That's not just a meeting with the attorney. That's another point of question we get. Well, we have a meeting with the attorney. Can't we close that meeting? Not necessarily. If you're going to discuss, let's call it litigation strategy, to use maybe a little more friendly layman's term, likely is you're going to be able to have that meeting closed because there's going to be attorney-client privilege communication that should not be open to other parties in the litigation who may, or pending litigation, who may be able to use it. But at the same time, just because the attorney is present doesn't mean you're going to have the ability to have a closed meeting.
Cindy, let me add something there.
Sure, Alan.
You know, since I'm generally on the litigation side, the legislature really didn't define what proposed litigation is. Some groups have taken a pretty broad reading of what that means. But for instance, if there's an owner who threatens litigation against the association, even though it's not the association necessarily that's proposing that litigation or that claim, at least I would interpret that to mean a litigation proposed by an owner where, for instance, you got a claim, a letter. To me, that would be sufficient to trigger the right to have that closed meeting because it's a litigation that's proposed.
Yeah, I mean, these contested issues, and I'll state the obvious because just it gives some comfort. If you're involving the attorney in the meeting, the attorney's going to be able to tell you whether, in their opinion, they believe it merits this closure for the other owners, or maybe it's a meeting at which you need to notice is open to the owners. But yeah, thank you, Alan. The statute is not a model of clarity. There's a lot of room for interpretation there. The other exception is board meetings for the purpose of discussing personnel matters. We also get some questions about that one in terms of, we want to maybe change management. Can we have a closed meeting and discuss that? Well, this is personnel, not management. Personnel really is for employee matters. So if you, for instance, you have a front desk employee, you're a large condominium association, maybe out on one of the barrier islands, and you have a front desk employee, and that front desk employee has a personal medical matter they want to discuss with the board, that's going to be a properly closed meeting. It has to do with employees' private personal information that really the association members don't have an interest in terms of that being private and personal, and also in that case medical. Next slide, please, Michelle. You may have noticed that was just condominium we were discussing. The concepts are the same though here for HOAs. Homeowner associations, meetings of the board must be open to all members, except for meetings between the board and its attorney with respect to proposed or pending litigation where the contents of the discussion would otherwise be governed by the attorney-client privilege. This is similar, a little different. Alan's point still stands. It's not a model of clarity. There's some vagaries here, but your association counsel can advise. Next slide, please, Michelle. How often do you have to have a board meeting? Well, that's going to be something that's probably in your governing documents for your community. There is no specific requirement other than you're going to have your annual, for both condominiums and HOAs, you're going to have your annual organizational meeting, as it's called, after the annual meeting of the owners, where the board of directors elect their officers for the year. Other than that, the HOAs do not have, in the HOA Act, a requirement for the frequency of board meetings. But the Condominium Act recently did add this last year, this requirement, that in a residential condominium association of more than 10 units, so that's going to be about all of the residential condominiums that are out there, although there are a handful that are smaller than that. The Board of Administration shall meet at least once a quarter. So if you're a condominium association with more than 10 units, and you're not commercial, you're residential, you do need to meet as a board at least once a quarter now, pursuant to this new law. So before I turn this over to Jennifer Hicks for the next part of the program, anyone have anything in the chat they want to bring up, or any questions or clarifications?
I saw a question.
I see.
Oh, you guys
Jennifer,
decide who goes
please.
first.
Someone has asked if do legitimately closed meetings have to be noticed?
Well, our advice is yes. There's not specific guidance in the statutes, but our advice is yes, notice it as a closed meeting. Because otherwise, if you don't notice it and at least let the community know it's taking place, that could be an issue that if you do end up in litigation, the other side could bring up as a potential procedural deficiency. So yes, notice that it's happening, but make clear that it's closed.
Here's a good
And I guess
question that
following on that, well, sorry, Jim, following on that, the minutes for a meeting like that, it's my advice that the minutes just state the closed meeting was held, who participated, when it opened, when it closed. No discussion. Go ahead, Jim, sorry.
I like this last question that popped up. What are the consequences for illegal meetings or voting by email? You know, and occasionally there can be some more dire consequences, but very typically what happens, excluding certain things, there are certain things that have been ruled now, or sort of, if you don't do it the right way, you know, they're done. And that's recently been held when it comes to making like material alterations to association property. If you don't obtain a vote properly to do that, you may be out of luck. But by and large, the penalty for failing to hold a proper vote or something like that is that you're ordered to do it properly. You're ordered to go back and hold a meeting at which the vote is properly brought before the board, and the board votes at that meeting and corrects the deficiency. There typically aren't steep consequences for meetings that may have not had proper notice, or if something was voted by email, it can be ratified at a subsequent meeting under certain conditions. So sometimes there are ways out, but sort of my broad answer to that question.
I would add to it that even if there aren't legal ramifications, I don't think it presents well to the community if a board gets called out for not following protocol and procedure. As I stated at the opening of the presentation, I think that it's very important to follow protocols and procedures so that your community, with the exception of the few folks who will never be happy, feel comfortable that your board is acting with transparency and following the requirements. So before I turn this over to Jennifer,
Can we ask somebody ask, can I ask one question, please?
well, we're going to do open questions at the end. So put your questions in the chat and we will, we'll address them from there. Because otherwise and I don't mean, otherwise we will lose the thread of the meeting basically. So, but do put it in the chat. We'll answer it. And if we don't answer it at the end, you can ask again. All right, Jennifer.
So now we know what the meetings are. What do we need to do to get ready for them? So you want a board meeting? Who can call a board meeting? So for the board members, if it's the president or the secretary, that is typically going to be controlled by your bylaws. So obviously we don't know all of your bylaws, so we can't say specifically per association. But go ahead and check your bylaws and see. Traditionally, it's either the president and or the secretary or a number of board members. But for owners, can owners call a board meeting? Traditionally, no. So with the condominiums, if 20% of the voting interest petition the board to address something, so if they say, hey, I don't know, we've got this disruptive owner and it needs to be addressed. So if you get as a board a petition signed by 20% of your owners, you as the board have to, within 60 days of receiving that petition, put that item on an agenda for the next meeting, the next board meeting, whether it be your normal board meeting or a special board meeting for that purpose. Now, it says you have to put it on the agenda. It doesn't say the board meeting has to be that soon, but going on the trust that we've been talking about, if you push that board meeting out as far as you can, you're going to lose your owner's trust, right? So enough of the owners have come to the board asking for this situation to be addressed. You want to address it pretty quickly. That way you keep the community confident and trusting in the board. Same goes for HOAs, 20% petition for the item to be put on an agenda. And it states that it has to be on the next regular or special meeting, but no later than 60 days. So for HOAs, you are constrained by the statute that you only have 60 days from the receipt of the petition to actually have that board meeting and discuss that item. So it's a little bit different between the two, but either way, get it on your agenda and get it addressed. So the owners can't call the meeting, but they can ask you to put something on an agenda. Now, who puts the agenda together? Other than what we just discussed, it tends to be board members. So unless it's specifically outlined in your bylaws, as a board and as a community, you are going to need a protocol that says, if, you know, whether it's a number of board members can put something on the agenda or specific board positions can put stuff on the agenda, That's really an in-house protocol item that needs to be addressed by each community. Again, as we said, the owners can force an item on the agenda, but you may decide as a community, you want to have a policy where owners can request items to be on the agenda, but that's going to depend on your community and how it operates. So that's something you definitely want to discuss with your general counsel. Now, where does the meeting have to take place? And we will get into Zoom meetings in a minute, but physically, it has to be within a certain mile range of your community. And that's going to be dictated either by statute or by your bylaws. Some of them say it has to be at the association's headquarters or home office. A lot of associations don't have that. The developers just didn't pay attention when they drafted those documents. So it's something to look at your documents for. But also, as we said, Zoom's a now very popular way to hold meetings. So for 718, which is the condominium statute, if you are using video conferencing, which, as Cindy said at the onset, the new statutory bill was signed and it does address Zoom meetings. If you are having a board meeting by Zoom conference, your notice must not only include your hyperlink to Zoom or whichever video conferencing system you're using, it must also now have a physical address. So even if you are holding your call by Zoom or Teams or whatever process you're using, if you are using video conferencing now for condominiums only, you must also have a physical location. You cannot hold it 100% by Zoom. For HOAs, you don't have that yet. The bill did not address HOAs using teleconferencing or video conferencing this year. However, if you have an owner who is physically disabled, you have to meet in a location at which that physically disabled owner can attend. So it does not require that person to actually ask the board for attendance rights, because as we know, as we were just discussing, they have the right to attend board meetings. So if you have an owner who, obviously the board must be aware, is physically handicapped, you have to meet in a location where they can attend. Next slide, please, Michelle. Now, who receives your notices for meetings, for board meetings? For a condominium, you are required, at possible, to post your notice and agenda for your meeting 48 hours prior to the board meeting. Now, there are some situations where it cannot be posted. And if it is not posted, it must be mailed, delivered, or emailed at least 14 days before the meeting. So you really are better off posting your notices if possible. And these are just your general board meetings. These are not any special topic meetings, which we will get into. But for your general board meetings, you are going to be posting them to the community 48 hours ahead. Same for HOAs. You have to post your meeting notices 48 hours ahead of time, or mail them 7 days prior to the meeting. Next slide, please. So like we were just saying, those requirements are for general board meetings. Now, there are certain specific board meetings in both HOAs and condos that require specific notices that are different from the 48-hour posting. For condominiums, if you are discussing and voting on special assessments, as I know we are all too well informed with this year, or too well experienced after the hurricanes, if you are voting on a special assessment, written notice of that meeting, which very clearly states it is a meeting for a special assessment and what the assessment is for, and also your estimate of your special assessment, all must be mailed, delivered, or emailed if your owners have accepted email notices, and posted on the condominium property 14 days prior. So this is one that we have seen a lot of problems with, because the owners don't get it timely if it's not sent 14 days before. And that's when you start having problems, when owners say, well, how can we know this is what you're doing if we're not getting the notice? And that's where you run into the trust issues again. So special assessments, everything goes out 14 days ahead of time. Now, if you are changing rules regarding the use of a unit, that also requires the 14-day notice and posting. Budget, when you are working on your budget, you have to post, you have to deliver to each owner 14 days ahead of time. So you're not only sending the notice, but you're also sending a copy of the proposed budget. So again, you're back to your 14 days. I think we're seeing a little bit of a trend here. If it is something other than your general board meetings, you're going to be looking at 14 days at minimum. Next slide, please. For HOAs, very, very similar. Your special assessments are also going to require 14 days notice. And your rule changes, we're not talking about your pool rules here. We're talking about your lot use rules. Those are going to require 14 days notice to the owners as well. Now, if you're sending these notices, what needs to go with the notices? So for condominiums, you are now required to send not only your notice and agenda, but if the board is voting on a contract, you must send the contract. So if you're looking at getting a new landscaper, that contract's going with that notice and agenda. HOAs, you don't have the contract requirement, but you are required to send your notice and agendas. I think that might be the end of mine. Michelle, am I at the end? Next slide, please. Okay, so before we move to Jim, do we have any questions we need to address?
I saw one that has come up and is coming up in some capacity with this new law too. What is considered posting? We are a condominium complex that has a minimal number of permanent residents. So posting in the mailroom, for instance, will not actually provide notice to the membership. Do you have an answer for that one?
Sure. The statute requires it's in a conspicuous place. That obviously changes depending on the layout or design of your community, both HOAs and condos. The best way to handle it in something like that is to really come up with a board policy of, okay, we have a lot of out of state, so let's post it as required, because that is honestly your best bet to be in line with the statute, but also you can email those notices as well. So as we've been saying throughout the presentation, trust is the goal. So if you're going to post it, but you know half of your community is out of state, go ahead and email it as well.
And I want to add, I'm seeing some issues about, well, can't we kind of go ahead and maybe have a consensus in our emails before a meeting, or following up to the question about what's the potential downside of just making decisions in emails before a board meeting. I just want to point out a reminder I didn't state before, and that is owners have a right to request to see the official records of the association. And those records can include emails between board members discussing matters that are coming up before the board. So I caution board directors to use email in a manner remembering that at some point somebody could get all of those emails under their rights to see them under the statutes, and then look and see how you're making decisions in a way that maybe looks like you've set it up, that there's not going to be a thorough discussion at the board meeting, or maybe there's being decisions made that you're trying to do quickly that could end up looking bad if put out to the community. Even though, again, I understand, particularly for those of you who are here to get educated and understand the qualifications, a lot of times you're just trying to get things done. It's not like you're getting paid any money to do this as board members. But again, that transparency that you want to have for the community is absolutely of the utmost importance to keep the community feeling confident in your decisions as a board.
Cindy, there was a question about if a majority of the board members get together, does that necessarily constitute a meeting that has to be noticed? In fact, the question the person asked was, if a majority of the board is presently on this session, are they holding a violative board meeting? And the answer, again, is it's only when a majority of the board is together and discussing association business that constitutes a board meeting that needs to be noticed. So if you attend an educational session together, that doesn't violate the statute. Or frankly, if you're at a party at the pool and all the board members are there and they're socializing and talking about things other than association business, that's not violative. And if you have a 5-person board and 2 of the board members are at the pool party and they're discussing association business, since they're not a majority, that's also okay. So don't be afraid to be together. Just avoid a majority speaking of on association business outside of a meeting, notice meeting context.
That's right, Alan. Spot on.
All
All
right.
right.
Active chat, but I think in the interest of time, I will move on to my section and allow some of the others. We'll also take some save some time for questions at the end here today too. So I'm going to talk to you about the meeting itself. And I think we've hit on it today, but it's always important to remember the difference between your board meeting and your membership meeting. We're talking specifically, at least I'm talking very specifically about board of directors meetings here. This is the board of administration for your association that's making the decisions about how your business is run. So in a typical association board meeting, your president is going to be that person who essentially holds the gavel, conducts the meeting, holds you to your agenda, guides you from topic to topic. For those of you who are familiar with Robert's Rules of Order, which does not by and large apply to condominium associations, but can in certain circumstances, they're the ones who are doing that job. They're holding the gavel, they're running things, they're running the show. Your governing documents can appoint some alternative to that. They can have a parliamentarian, they can say, appoint somebody specifically to hold you to that. Of course, if your president is absent, whether due to illness or for any other reason, it's typically your vice president who will step up. It's usually the role of the vice president position is to step in and fill in for the president when they're not available and to do everything the president can do, just sort of second in charge. Of course, any other officer, should your president and vice president still be absent and you still have a functioning board meeting, any other qualified officer can go ahead and run that meeting. But you typically start with your president. And of course, every decision for your association that requires board action, board approval should be decided by a vote. Your governing documents can lay out exactly what the criteria for your board's approval may be through that vote. Typically, once a quorum is established, it's often a majority of the quorum is necessary to approve a board action, but that can vary by your governing documents. It's important that as directors, as officers as well as directors, should you be your president, your vice president, you're familiar with your bylaws and you understand exactly what it takes to get your meetings going, what it takes to make them valid meetings, and what it takes to approve board action. If you can go to the next slide. So let's talk a little bit about owner comments. This has been an issue that has certainly changed over the past couple of years. First of all, when are owner comments permitted? Florida law requires that owners be allowed to speak on any designated agenda item before board takes action. So by default, every board meeting out there that has an agenda, the membership in attendance at that meeting are allowed to speak on those agenda items. They have to be allowed to speak on those agenda items before the board makes any decisions. It doesn't make a lot of sense for the board to vote on an issue and then go, all right, membership, tell us what you think. It may be too late at that point. Now, there's some additional nuance that has come into play over the past couple of years, especially with condominiums. So a condominium with at least 10 units, and there certainly are smaller associations out there, but by and large, that's most condominium associations in Florida, must meet at least once a quarter now. That, of course, is 4 times a year, but specifically, you have to meet once a quarter. So once every 3-month period, you have to have a meeting. Now, separately, or it can be at those same 4 meetings, there's another statute that says your agenda must allow owners to ask questions of the board on any topic related to the association. Now, again, this is just condominiums. But that's an open question period where your membership, at least 4 times a year, now if you're only having your 4 quarterly meetings, it's going to be at those quarterly meetings where you give them this option. They can talk to you about things that aren't even on the agenda. As long as it pertains to your association, the association business, maintenance projects, whatever it has to be, they can talk to you about that. Now, if you have an owner who wants to get up and talk about national politics, you can, and I believe you may even have the moral obligation to tell them to sit down and not discuss that at your meeting. This is limited purely to association business. So that's important, and condominiums now have this open forum at least 4 times a year for their membership at board meetings. HOAs, you don't have any sort of statutory requirement for the number of times you need to meet per year. You don't have to give this open forum to your membership. For HOAs, whenever you have your board meetings, your members are limited to discussing items that are on your agenda. You do have the right to impose certain rules and regulations about that. I think we may talk about that a bit more in the next slide. Let's go on to the next one. And we do. So you can pass rules and regulations about, and this now applies to condominiums as well. Any association in Florida can impose rules and regulations concerning how members address the board. Typically, those rules come in the form of a time limit. You're allowed to speak about anything on the agenda for up to 3 minutes. You may speak at a meeting for up to 3 minutes once per meeting. Now, they have to be reasonable. You can't, I mean, 3 minutes has been held to be reasonable for most associations under most circumstances. You can't say you have 1 minute to discuss everything. You can't place an unreasonable burden on your membership and try to silence them. These statutes are all designed to encourage membership cooperation with the board, to enable the board to understand what its members want and have the members have a say in how your association is run. Of course, as has been apparent in the chat, there are also those owners who are disruptive, who wish to discuss items that are inappropriate for a particular meeting, and that's when those rules really come into play. To some extent, the board, the president, as I said, who's typically running these meetings, is going to be the one responsible for saying, all right, we've drifted off topic, or all right, your 3 minutes are up, and can ask the owner to step down and cede the microphone to the next owner. For those owners who refuse, sometimes, like I said, the president has the authority to say, hey, step down, your time is done. If they refuse, the president can ask that disruptive owner to leave. If the owner refuses to leave and refuses to sit down, it may be that you have to call the authorities and have them removed. You may have to end the meeting, adjourn it until such a time as order can be restored. But disruptive owners are certainly a hot topic, and we actually offer an entire course on that. So unless we want to be here all day, I'll also talk to you a little bit more of that. The topics that members can discuss at these meetings. Unless we're talking about that 4-time-a-year condominium open mic session, your members really are restricted to the items on the agenda. And that's to prevent meetings from really wandering off course. It's to keep you on topic, to discuss the appropriate business that's before the board, and to make sure that the business can be handled appropriately. So again, they shouldn't be drifting to unrelated topics. And unless you're a condominium in your 4-time-per-year meeting where they're allowed to discuss other issues, they are restricted to the agenda. Next slide. Recordings. Recordings are allowed. Owners are allowed to record your board meetings. They can audio record, they can video record. The statutes are on the screen for both condominiums and HOAs, which pertain to the recording of board meetings. It's not a right to privacy issue. It's a meeting. They have the right to attend. They have the right to take notes. They have the right to record. The board may adopt rules, again, sort of making sure that those recordings don't become a disruption. Those typical rules are requiring the devices to be stationary. You don't want somebody holding their phone, walking around the room, getting in directors' faces, blocking other people's views. Again, we don't want a disruption here. So you can require that they be stationary cameras, or that their phones are placed flat on a table so that they can record the voices. But again, you're avoiding disruptive behavior. And that's what your recording rules should be designed toward. You don't want somebody with 12 cameras coming in and turning this into some sort of media circus either. So it's all within reason, as rarely as that may appear in your board meetings. I do want to talk briefly about House Bill 913, which some of you may be aware was recently signed by the governor and will become effective July 1st. That's going to have to do with Zoom meetings and amongst other things. And here specifically, when it comes to recordings, and I'm not going to get too deep into it, but if you allow your board meetings to go forward via Zoom or telecommunication device, those meetings have to be recorded starting July 1st. Those recordings are going to become official records of your association, and they will have to be maintained for 12 months after that meeting. Now, there's more detail that goes into that where, it's not effective law yet. It becomes effective July 1st, and we'll be providing more information about that separately. But just something to be aware of, because July 1st is just days away, and some of you are doing Zoom meetings or Zoom functional meetings, so you need to be aware that you may need to either stop offering Zoom meetings or be prepared to record those meetings come July 1st. And briefly, again, just talking about disruptions when it comes to board meetings, you can have decorum rules. You can say no yelling, no screaming. We talked about time restrictions. We talked about content restrictions. You can do that sort of things at your meetings. Like I said, the president warns disruptive owners. If they fail to comply, they're asked to leave. If they fail to comply, they can be escorted out by the police if necessary. It's pretty extreme, but can be done. Next slide. And I believe this is my last slide here, and I just want to talk to you briefly about minutes. This is a question that comes up very often. Who keeps your minutes? Well, typically that would be your secretary, though anyone else can be delegated that authority. The board can delegate the authority to record your minutes to the CAM, but it's ultimately going to be the board's responsibility to ensure their accuracy. So anybody who's taking those minutes will have to do a good job, and the board will have to confirm them. So, and again, the statutes are on there regarding what, for both HOAs and condominiums, concerning the requirement to keep minutes. Minutes should include the date, time, and place of the meeting. They should include the names of the board members present, motions that are made by those directors, those board members, who made them, what the motion was, whether they're seconded, and whether they were passed. This is the official record of your association's board of directors. This is the record of how your business is being operated. It's very important that these records be concise, that they reflect what was done, so that in the end, if somebody asks that question, you can pull out the minutes from that meeting and say, sure, Director John made the motion to hire that contractor. It was seconded and it was passed. The board made that choice. Absent those minutes, it's often very hard to prove that something was done and it was done properly. Minutes should be concise, factual, and there is typically a requirement that they're approved at the next meeting, or at least a subsequent meeting. So one of the items on your agenda should be approval of previous meeting minutes. And again, that's where it's going to be, no matter who's recording those minutes for you, you're going to want to have them typed up, organized, and put in an official format so that at one of the next meeting or meeting after, the board can look at them, review them, make changes if necessary, and ultimately vote to approve them. And that way, again, you have a clean, concise record of what your corporation has done, and you can support your good business decisions down the road. And with that,
Jim, before we get off of minutes, and to reiterate what you're saying about the minutes being concise, we've had some horror stories, and I'm talking about from the court or litigation side, because eventually, if there's an internal dispute or an external dispute goes to court, there'll be a request for production to produce the association minutes. I had a case, in fact, the president of the association was a lawyer, and right in the minutes, in the president's report, he almost stated verbatim what our opinion was on an issue that was actually involved in the litigation, the strengths and weaknesses of the case. Even said, according to our lawyer told us that it went on for about 3 pages. Of course, the other side was able to discover that set of minutes through a request for production, and it was really too late to withhold or redact what was there. So, number one, don't repeat what your lawyer told the board in confidence in open meetings. And secondly, beware of what you place in there. We've also had situations where there's a dispute between an owner and the association, and there's all kinds of expletives and slanderous statements and so forth that get stuck into the minutes, which have caused associations a lot of problems. So the emphasis is, as you say here, date and time of the meeting, who was present, motions made and the results, I often find sometimes it's a ex-English teacher or professor who gets to be the secretary of the association, and they feel a need to record everything that went on at the meeting, every discussion, every dissenting voice, and create beautiful minutes that are about 10 pages long. That's only going to cause problems. So they should be really restricted to what you've indicated here.
And I usually say it when it comes to director emails specifically, but to some degree it applies to any official document of the association. I think directors need to assume that anything that's being reduced to writing is going to be read by, just imagine that everybody in that association is going to read it someday. If you're being sued, it's going to be read by the other lawyer. Assume that it's going out there, and if you comport yourself properly, if you watch what you say, if you make sure the records are accurate, honest, and concise, and you keep some personal stuff out of it and you keep directly on point, you're going to find yourself being a lot happier down the road. So you just imagine everybody's going to read these someday, and that should help keep your content to what it needs to be.
Jim, what do you think about an item like a manager's report or president's report or the treasurer's report being attached to the minutes as part of the meeting minutes? What's your thought on that?
Well, I think it's a good idea, because those things are going to become official records anyway. So if they're going to be discussed at a specific meeting, and again, perhaps from a litigation standpoint, down the road, when we get a request for those meeting minutes and we get a set of minutes from 3 years ago that says, this treasurer's report was attached, and the treasurer's report is not there, we're left trying to see if we can hopefully find the right report that was generated at that time and connect it together. So to the extent anything is going to be discussed at a meeting, I think it should be there. And of course, there is a requirement and I think Jennifer mentioned it, regarding contracts that are going to be approved at meetings. Those contracts should absolutely be kept with the minutes as well.
Well, on that point again, it's a ticklish issue, especially for management, when there's a problem, like a reoccurring problem in the community, and the manager wants to emphasize to the board that the problem needs to be taken care of, to actually include that in the manager's report rather than maybe just a statement to the board, to the president off the cuff after the meeting. For instance, if there's a dangerous condition on the property and the manager has something in the report, such as, this is the third time I've told the board about that tripping hazard. Obviously, think about the context of that. The manager wants to make sure that they're on record that they've reported something to the board. But if later an owner or guest ends up tripping on that tripping hazard, that's going to be a very piece of valuable evidence for the plaintiff, that manager's report. So there's a fine line between again, how much to include in that and how much to avoid.
Absolutely.
That you put in a report like that. Cindy, one of the things we talked about, the closed meeting. Is it allowable at a closed board meeting for a vote by the board to be taken?
Well, that's going to be dependent on whether the closed meeting, first of all, is a proper closed meeting, and then second of all, what the vote would be. For instance, if it's a closed meeting, because let's just use an easy example, because there is litigation, there is a lawsuit the association is involved in, and there's a potential settlement on the table. That's something that the board is going to need to make a decision on, and they're going to have to do it at a closed meeting in private. So yes, you could potentially vote at a closed meeting depending on the circumstances.
Well, the emphasis, though, again, because we have faced that situation, is that obviously the minutes should not record that what the precise element of the vote was.
Correct.
I mean, would you say that the minutes, and you indicated before, you said the minutes should merely indicate that the closed board meeting occurred, but if there's a motion made at that meeting to approve a settlement or a settlement offer at a certain value, should the minutes even indicate that a motion was made and passed at that meeting?
No details regarding that decision should be posted in the minutes because the meeting is closed for the purpose of the board to have a discussion and make a decision within those protections for attorney-client privilege discussion and ongoing litigation. So no, I would not advise putting anything in the minutes other than what I advised earlier. The fact that there was a closed meeting held, who attended the meeting, when it opened and when it closed. To the extent that there needs to be confirmation later in the settlement agreement that the board agreed to it, that's going to be something the attorneys will have knowledge of. It doesn't need to be made public and potentially void something for sharing settlement information outside the parameters of the board discussions.
And I'll pose this question to you too, Cindy, because I know we've talked about it and I see it coming up. People asking about executive committees and, what can be done at an executive committee? What has to be done in an open meeting? Are there limits on what an executive committee can do, or does it depend on the bylaws? And I don't know if you'd like to talk about executive committees and some terminology and how that may be used.
Well, executive committees, again, going to depend on your bylaws, but might really be being used as a meeting. Let's say you have a 9-person board, and then maybe you have an executive committee of the president, the treasurer, and the secretary, who routinely meet and have discussions about what's happening with the association, what's going to come in front of the 9-member board. I just use that as an example. Because honestly, if you have a smaller board, for instance, if you have a 3-member board, having an executive committee wouldn't really probably make any sense. You're already so small that your decisions are already made by a small group. So I use those examples because that question can really be loaded that way. It might make sense for the business association to have an executive committee that keeps matters moving as the larger board meets less routinely. Or it might not make any sense to have an executive committee. Matter of fact, it might look like you're trying to avoid having open board meetings. So it's really hard to answer those questions and avoid, other than be very careful that you are getting guidance from your association counsel if you are using executive meetings to make sure you are complying not only with the statutes we've discussed here, but what is also in your bylaws. Because if you have a very large board, you probably do have some provisions in your bylaws about how an executive committee would work.
See any other questions you want to answer?
I want to add
go ahead.
I was just going to say, I've seen a lot of questions about what do we have to now notice on the website? What do we have to, I hate to say this, but the new law really just game changed a lot of the video conferencing, what needs to go on a website, all for condominiums. So I haven't answered, and I'm sure the others haven't answered some of those questions because they are going to be part of the new laws. So again, I'm going to encourage everyone to look at our websites when we get the legal updates up.
Yeah, one of the things we face, and if you have a 3-person board, you see the dilemma there. In a 3-person board, 2 of the board members could never discuss association business outside of an open board meeting. So one of the things we recommend as a standard practice, if you, let's say there's a new association that has turned over, there's a 3-person board with, and there's some leeway given to increasing the size of the board. It's really essential that that board be increased to a 5-person board if it's possible, because leaving yourself in a situation where none of the board members can discuss any association business outside of an open meeting creates really a practical impossibility. So we've seen some groups say, well, we like a 3-person board. It keeps it concise, and we don't really think anybody else is capable of serving on the board, whatever the reason is. It presents an immediate dilemma for association operation, because it's kind of the board members are muted unless there's an open board meeting, which unless you call a lot of board meetings, that's going to be very difficult.
So I just say someone popped up saying, regarding the question of who wins or which documents win, your condo documents or the statute. That's not a blanket answer. For instance, with meeting notices, we told you, or I told you, that certain meetings have 14 days and some are 48 hours. That is what the statute says. Your governing documents may say otherwise. But in that case, if your governing documents say 24 hours, the statute is stricter than that at 48 hours. So you would follow the statute. So neither always supersedes the other. I think we had someone who wanted to ask a question verbally. Did we?
That
There's
was,
definitely been at least two. Yeah.
Yeah.
I was one of them, and I wanted to go back to the beginning. So I was the one who talked about the unhinged homeowner we had with the signs and the recording and all of that. Because this homeowner is sending us cease and assist every time we do a violation, and they are threatening homeowners and they are getting in homeowners' faces. We are having a closed meeting on July 1st to discuss what legally as a board can we do, with the attorney, because we know we have to stay as neutral as possible. Is that warranted as a closed meeting because we are discussing a homeowner and what they are doing? Because we don't want the rest of the community to be, obviously nervous or scared. We're trying to, keep this, as neutral as we can. Is that something a closed meeting warrants, or would that be something homeowners would be allowed to attend?
Well, I could take that question, Cindy. Again, we don't always agree internally on some of these issues, but when I read the statute and it talks about proposed litigation, if you're having a dispute with an owner and potentially bringing a covenant enforcement action or some sort of injunctive relief against that owner is contemplated, to me that qualifies as threatened litigation that would justify a closed meeting. Sometimes the idea of what your remedies are to discuss with your lawyer. Again, I would see it in the broad concept of that being proposed litigation. Doesn't mean there has to be a motion passed that we're going to go into court, but it's a dispute. You're talking about strategy. You're talking about potential defenses that the owner may have, and the logistics in enforcing the rule and regulation. And to me, as a litigator, that would qualify as a proposed litigation. And Cindy might disagree, but as litigators, we're very concerned about our strategies not being exposed, and so therefore we take a little broader context of what that terminology means.
Okay. No, that helps. Thank you. Because we know these homeowners would get on the call, and obviously if we're discussing them, we don't want to give them any, for lack of better words, any ammo because of just how they are. So no, that answers it greatly. Thank you.
Can I ask a question?
Sure.
Does an item that is known to be motioned and likely voted on at an upcoming meeting need to be listed on the agenda as such?
Generally, if you know an issue is going to be voted on, put it on the agenda. Because if it's not on the agenda for the vote and then you vote on it as a board, you're then put in the position of having to justify why you did that.
But it's not required though, by law.
I can't say that it's not required because it could very well be required depending on the circumstances. So I can't say no. You asked the question generally, so I answered it generally that my advice would be anything that the board has reasonable belief to, whether it's going to be a legal requirement or even just a decision. If they know it's going to be a decision that it's upcoming, put it on the agenda so it can be voted on at the meeting.
Sure, that makes common sense, but there's no Florida statute that you are aware of that requires that to be on the agenda if it's known to be upcoming?
There is no statute that says any issue that's known to be upcoming should be on the agenda to be voted on, but there are statutes that govern specific decisions the board is going to make. Such, for instance, give an example, a special assessment. You can't just decide to impose a special assessment at a board meeting without following the notice and agenda requirements.
Sure, I understood that. But
Okay.
Jim or Jen or Cindy, you see any other questions we need to hit before we close?
Seems like everybody's been pretty active in the chat today. I've been scrolling up and it looks like almost everything has an answer. So
And
I keep starting back at the top and coming down.
unfortunately, some things we just can't answer. They're too detailed or really are going to require document review. So sorry to disappoint on some of those questions, but some things we just can't do without more knowledge.
All right, at this juncture, folks, we're going to close our session for today. We will see you again with another issue of interest in the next session. This presentation will be on our website in about a week with a transcript. So anybody who wants to have their other board members review this, just go to our website, hilltannenbaum.com, under news and resources. Not only this session, but all the prior sessions are on there. So thank you very much for attending today.